Good day. My name is Jody Phillips, and I would like to thank you for joining me in my presentation today. We will be talking about human rights legislation through the lens of a specific case, BJ v. Ponies R Us 2020, as heard by the Ontario Human Rights Tribunal 2020. The case file number 2018-34456-I. We will first look at the facts of the case, including the key people involved in the case, the details of the case, including the application before the tribunal, the respondent's response to this application, the events that led up to the applicant's complaint, the legislative references used to decide this case, the tribunal's decision, the remedies ordered by the tribunal, and finally, some analysis and opinions related to this particular case. So let's get started. Case BJ v. Ponies R Us 2020. This case was heard by the Ontario Human Rights Tribunal. The adjudicator assigned by the tribunal was Catherine Bickley, Vice Chair. There are a number of key people in this case. First of all, the applicant, known as BJ in the application and proceedings due to his age. The applicant's mother, the respondent, Mr. Huell, and the respondent's wife, Ms. Huell. We will begin by looking at the key details of the case, both from the application and the response. The applicant was a 15-year-old at the time of the events. The applicant is deaf. The applicant alleges that his human rights were violated in his application to the Human Rights Tribunal and that he was discriminated against on the basis of a disability, more specifically because he was deaf. The respondent, Ponies R Us, claim it was simply a misunderstanding. Now we will look at the details of the case, with the events prior to the applicant's first day. The applicant's sister had worked for Ponies R Us a few years prior to 2018. She was hired by the owners through an informal process that did not include an interview or a formal orientation process. The sister's job with Ponies R Us is how the applicant's mother came to know Mr. and Mrs. Huell and the company, and what led her to contact them regarding work for her son. The applicant's mother made an email contact with Ms. Huell inquiring about availability of work for her 15-year-old son, the applicant, on or about August 22, 2018. She explained at the time that her son was deaf and was able to communicate via written notes and hand gestures. The owner's wife responded positively, asking when her son would be able to start. A date, a time, and a place were established for the applicant to begin work the first weekend in September of 2018. In response, the applicant's mother sent a follow-up email inquiring about the dress code and lunch arrangements. These emails initially went unanswered. However, on August 31, 2018, the response was received that due to scheduling issues, the applicant's schedule was canceled, but that he could come the following weekend. The applicant's mother responded and confirmed. There was no further emails from Ms. Huell or Ponies R Us up to the date the applicant was expected to report to work the following weekend. We will continue now looking at the details of the case, including what occurred on the applicant's first day. The applicant, accompanied by his mother, arrived at the scheduled time and location. The applicant and his mother were greeted by the owner, who handed the applicant the reins to one of the ponies. The applicant's mother spoke for a short time with the owner, Mr. Huell, before leaving for home. The applicant worked alongside 3 other employees assisting the children with pony rides that morning. The applicant indicates that the morning was uneventful. The applicant's mother then received an email at 10:30 that morning from the owner's wife, Miss Huell. The email requested that she come and pick up her son at lunchtime. Miss Huell explained that there must have been some miscommunication and the applicant was not scheduled to work. She further indicated that after discussion with her husband, they felt it was not safe for her son to work with children and the ponies as he could not hear potential dangers. She apologized and agreed to pay him for the day and also to look for other opportunities at the farm for the applicant if the farm had any other work for him. The owner testified that the other employees working with the applicant texted him indicating they thought the applicant was actually there to work and that he had believed that the applicant and his mother were simply there to visit the farm. In adjudicating this case, the adjudicator of the Human Rights Tribunal, Catherine Bickley, referenced a number of provisions in the code, including Section 5, subsection 1, which protects all people from discrimination on the basis of a protected ground, including but not limited to a disability. Section 10, subsection 1A, which states that a disability includes any degree of deafness or hearing impediment. Section 11, subsection 1, that a factor that is not discrimination on a prohibited ground, but nonetheless restricts or excludes a group of or persons who are identified by a prohibited ground, except where the factor is reasonable and bona fide in a situation or does not infringe on the right. Section 11, subsection 2, which states that the tribunal will not find the right was infringed if the person cannot be accommodated without undue hardship. The first decision the adjudicator of the Human Rights Tribunal had to make in this case was whether or not the applicant had established a prima facie case of discrimination. And she did so, confirming that the applicant had made his case based on the following facts. The applicant was removed after a half day of work, during which there was no evidence that there were issues. Mr. and Mrs. Huell were not present during the half day and called no witnesses to support their concern. The respondent's argument that the applicant was never hired and that there was a miscommunication was in direct contradiction to the enthusiastic emails from Ms. Huell. The applicant's sister was also hired in a similarly informal process, which suggests there is no formal hiring process that would include an interview, evaluation, or an orientation. Mr. Huell handed the applicant the reins of one of the ponies, an indication that the respondent knew he was there to work. In August, the applicant's mother advised Ms. Huell that her son was deaf and that Ms. Huell raised no concern at this time. Mr. Huell testified that he was not aware that the applicant had been hired, yet in Ms. Huell's email on the day in question, she suggested that she had discussed the safety concerns with Mr. Huell that week. Mr. Huell is the sole proprietor of the company and was liable for his actions. The second question that required an answer was whether or not the respondent was able to establish a bona fide occupational requirement as a defense to the discrimination. The adjudicator of the Human Rights Tribunal, Catherine Bickley, found that they did not and referenced a number of facts that led to her decision, including the respondent used as evidence a Wikipedia entry indicating pony rides are high-risk activities. The adjudicator finds that Wikipedia is not a reliable source of information, as in part, they are not subject to independent fact-checking. The respondent submits an excerpt from an insurance company website that state that pony rides pony ride operators are exposed to a high risk of liability. The adjudicator gives this no weight, indicating the excerpt was from a promotional material that was developed in an effort to sell operators liability insurance. The respondent submits an info sheet from the University of Guelph that recommends not using cell phones while handling horses. The adjudicator found that this referred to the distraction that a phone might have when used for recreational purposes, and that a ringing phone may startle horses. This did not prove that using a phone as a communication device for a deaf person would create a similar risk. The respondent presented that pony rides are dangerous by nature. However, this is a contradiction by the fact that in 21 years of operation, there was never an insurance claim. The respondent referenced several points that referred to dangers, including dogs, balloons, yet there was no evidence that this caused problems in the 21 years the company has been operating. In rendering her decision, Catherine Bithley ordered the following remedies to be applied. Mr. and Mrs. Huell to obtain training provided by an expert in human rights law within 6 months. The training to include obligation of employers under the code. The expert is also to provide assistance in writing a human rights policy for Ponies R Us. Ponies R Us are to post the above-mentioned human rights policy to their website. The applicant will receive lost wages in the amount of $600, which covers the weekends he would have expected to have worked. Although the applicant was not seeking compensation for injury to dignity, feelings, and self-respect, the adjudicator requests written submissions on this from both parties in order to consider an appropriate amount of such an award. After reviewing this case, I find the following interesting. The case reinforces the need for the proper formal hiring process to be in place, regardless of the size of the company or the expected length of employment. It also highlights that email communication can be helpful in understanding the facts of a situation that verbally recalled conversations cannot provide. The preparation of the respondent's defense, in my opinion, was flimsy and not well prepared. There may have been a case to be made. However, it was haphazardly prepared and demonstrated the lack of understanding of the law by Mr. and Ms. Huell and the need for proper legal representation. It was also very interesting to me that the simple action of turning over the reins to the pony was enough to confirm for the adjudicator that the applicant had been hired. I want to take a moment to thank you for taking the time to review my presentation today. I wish you all well in this difficult time as the world fights the dangers of COVID-19. Please stay home, isolate, protect the vulnerable, and wash your hands. We've got this.